Good afternoon, everyone. Welcome to this afternoon's meeting. Before we get started, I'd like to ask everyone to please take a moment and bow your head for a moment of silent reflection. Amen. Thank you. Okay. Before we get started, I want to welcome our consumer advocate, Ms. Carrie Liebarker, and the assistant consumer advocate, Ms. Becky Dover. Welcome, y'all. Glad to have you here. And I will now turn it over to Mr. Minges.
Thank you, Mr. Chairman. Good afternoon, Mr. Chairman and Commissioners. For our next commission meeting, we have a special commission meeting scheduled for tomorrow, January 30th at 2 o'clock. And our next regularly scheduled business meeting will be next Wednesday, February 5th at 2 o'clock.
Very well.
We have two supplemental items on our agenda today. Item number 1, docket number 2019-64WS. This item corrects a discrepancy in last week's motion.
Mr. Chairman.
Commissioner Howard.
Mr. Chairman, a discrepancy occurred between the operating margin and revenue requirements stated for CUC and the Commissioner's Directive of January the 22nd, 2020. The directive approved an increase in operating revenue of $136,302, resulting in a total operating revenue of $1,421,148, with a net income of $177,786, an operating margin of 12.51%. However, CUC has calculated that an increase of $136,202 would result in an operating margin of 12.05%. The company states that the Office of Regulatory Staff agrees with the calculations. CUC has calculated that an operating revenue increase of $146,900 is necessary to achieve a 12.51 operating margin. I move we accept the operating revenue of $146,900 as the accurate reflection of the operating margin of 12.51%. I further move that the company submit a tariff consistent with the Commissioner's stated operating margin of 12.51%. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye. Aye. All opposed, no. The motion carries. Thank you.
Chairman, item number 2, docket number 2020-16T. We have a request for a tariff amendment.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we approve the request of Soda City Movers, LLC to amend its tariff. The Office of Regulatory Staff has reviewed the application and has no objection to Soda City's request. According to ORS, it finds the company is in compliance with the company's rules and regulations, and including annual report and gross receipt filing requirements, and it has not received any customer complaints in the past 12 months. So moved.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye. Aye.
All opposed, no. And the motion carries.
Turning to our utilities agenda, item number 1, docket number 2020-20C. We have an interconnection agreement.
Mr. Chairman.
Commissioner Howard.
Mr. Chairman, I move we approve the interconnection agreement between Farmers Telephone Cooperative Incorporated and Teleport Communications America, LLC. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 2, docket number 2020-15C. We have a petition to intervene.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we grant the petition to intervene filed on behalf of the South Carolina Telephone Coalition. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 3, docket number 2017-79G. We have a third amendment to a gas agreement.
Mr. Chairman,
Commissioner Belser.
I move that we grant the request for approval of Amendment 3 to the agreement for transportation service with firm gas standby between Dominion Energy South Carolina Incorporated and Waste Management of Carolinas Incorporated. So move.
Thank you. You've heard Commissioner Belser's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 4, docket number 2017-45G. This is the second amendment to a gas agreement.
Mr. Chairman,
Commissioner Belser.
I move that we grant the request for approval of Amendment 2 to Agreement for Transportation Service with Firm Gas Standby between Waste Management of South Carolina Incorporated and Dominion Energy South Carolina Incorporated. So move.
Thank you. You've heard Commissioner Belser's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 5, docket number 2019-387A. It's a petition to intervene.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we grant the petition to intervene filed on behalf of Blue Granite Water Company. So moved.
Thank you. You've heard Commissioner Whitfield's motion. Questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 6, docket number 2019-387A. We have a petition to intervene.
Mr. Chairman,
Commissioner Irvin.
I move that we grant the petition to intervene filed on behalf of Dominion Energy South Carolina Incorporated. So moved.
Thank you. You've heard Commissioner Irvin's motion. No questions or comments. All in favor, please say aye. All opposed, no. And the motion carries. Thank you.
Item number 7, docket number 2019-387A is another petition to intervene.
Mr. Chairman,
Commissioner Howard.
Chairman, I move we grant the petition to intervene filed on behalf of South Carolina Department of Consumer Affairs. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. The motion carries. Thank you.
Item number 8, docket number 2018-248E. We have a request to approve a retail power sales agreement.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we approve the retail power sales agreement between Shaw Industries Group Incorporated and Dominion Energy. I also move that we approve the parties' request for confidential treatment of the agreement. They maintain that the agreement is commercially sensitive and proprietary in nature.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 9, docket numbers 2019-184, 185, and 186E. We have a motion to withdraw Stinson Woodward Ferguson Esquire as local counsel.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we grant the motion to withdraw Stinson Woodward Ferguson Esquire as local counsel. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments?
Mr. Chairman,
Yes, sir.
let the record reflect that I've recused on these 3 dockets, will not be voting.
We will let that reflect that you are recused, Commissioner Irvin. Thank you. Okay. Any other questions or comments? Not all in favor, please say aye. Aye. All opposed, no. Motion carries. Thank you.
Item number 10, docket numbers 2019-185 and 186E. Staff proposes that we carry this item over for a special commission business meeting that's been scheduled to address this matter tomorrow, January 30th, 2 o'clock.
We will carry it over. Thank you.
Mr. Chairman, I will not be attending that meeting for the same reason that I've recused on these 3 dockets.
Thank you, Commissioner Irvin. We'll have that noted.
Item number 11, docket number 2019-365E. We have a request for an extension of time.
Chairman,
Commissioner Belzer.
I move that we grant the request of the Office of Regulatory Staff on behalf of all interested parties for an extension of time until February 6, 2020, to file suggestions.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments?
Mr. Chairman, if I might,
Yes, ma'am.
I know that there's been some interest in the filing made by ORS and that parties, other parties filed letters indicating it, whether it would be granted. The reason that it took so long is, or didn't take so long, that we couldn't issue a standing hearing officer directive on that because the date was set by an order of the commission last week, so it had to come back before us to amend or change that date. And that's why staff couldn't respond to it with a standing hearing officer order. Thank you.
Thank you, Commissioner Belzer. Any other questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 12, docket number 2019-241EG. This matter concerns smart meter opt-out riders.
Mr. Chairman,
Commissioner Belzer.
Dominion seeks to begin its advanced metering infrastructure, also known as AMI, installation deployment during the second quarter of 2020. In compliance with Commission Order 2019-622, Dominion submitted an AMI customer education plan that provides specific detail on how the company will communicate AMI deployment to its customers, the availability of the opt-out requested by the Office of Regulatory Staff, and the benefits of AMI for customers. For customers to opt out, Dominion has proposed smart meter opt-out riders for retail, electric, and gas service, which include a one-time establishment fee of $168 and a monthly rate of $15. Following receipt of the request for approval of the opt-out riders, the Commission issued Order 2020-42, which asked Dominion to further explain the $117.92 information technology charge, which is a component of the one-time establishment fee. The company complied on January 24, 2020, by explaining that there are significant IT system costs associated with implementing and administering the new smart meter opt-out, and only a relatively small group of opt-out customers, estimated to be 736 customers, from which to recover these costs. I find Dominion's explanation and the accompanying detail in its filing to be reasonable. I note that ORS has previously reviewed the opt-out riders and the calculation of the one-time fee and the monthly fees, and ORS states that it supports the application, including the customer education plan and the riders, and recommends approval. I appreciate Dominion providing the greater detail that we requested and the letter of support provided by ORS. After reviewing these documents, I move that we approve the customer opt-out riders as submitted. That's my motion.
Thank you. You heard Commissioner Belzer's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 13, docket number 2019-281S. We have a request for a public night hearing.
Mr. Chairman.
Commissioner Howard.
Mr. Chairman, by order number 2020-62, issued on January the 22nd of 2020, the Commission granted requests for a public hearing in Richland County, and no further action is needed for these requests. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
We'll take items number 14 and 15 together. Item number 14 is docket number 2016-80A. Item number 15 is docket number 2016-80E and 2016-82E. These items concern requests of Duke Energy Carolinas and Duke Energy Progress for modifications to their respective residential energy assessment programs.
Mr. Chairman,
Commissioner Irvin.
Duke Energy Carolinas LLC and Duke Energy Progress LLC have requested approval for modifications of their residential energy assessment programs. The companies propose modifying these programs to offer additional measures at a reduced cost for those who choose to purchase them at the time of a home energy audit. Specifically, the companies seek authorization to offer additional measures for sale to the customer directly from the energy specialist at a discounted cost to facilitate customers' ability to follow the energy specialist's recommendations. Duke states that these measures could include, but are not limited to, the following: handheld low-flow shower heads, specialty lighting, recessed LED bulbs, and smart thermostats. Each of these measures will be installed during the in-home assessment. Duke maintains that adding the availability of additional measures to the programs should increase the overall cost effectiveness of the program by adding savings opportunities at a minimal cost to the customers. In addition, Duke also proposes to add a provision to the tariffs clarifying that any current and future environmental, energy efficiency, and demand reduction benefits and attributes, including all reported and compliance rights, will be retained by the companies in consideration of the incentivized discount purchase price. The Office of Regulatory Staff has reviewed this proposal and does not oppose granting the request. Therefore, I move that we approve the request as well as the additional provisions to the tariff as outlined. So moved.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 16, docket number 2013-298E. Duke Energy Carolina seeks approval for modifications to its Neighborhood Energy Saver program.
Mr. Chairman.
Commissioner Irvin.
Again, Duke Energy Carolina seeks to modify the Neighborhood Energy Saver program. Currently, the program uses third-party and consensus data to identify neighborhoods in which 50% or more of the households are equal to or below 200% of the federal poverty levels, and all households within an identified neighborhood are eligible to participate. Duke Energy Carolinas sends a team into those neighborhoods with a package of energy conservation measures to perform energy audits in the home and directly install the measures while on site. The company seeks approval to provide additional measures such as insulation, duct sealing, air sealing, and a smart thermostat to households within the eligible neighborhoods that consume more energy per square foot than homes of similar size and construction. In other words, these are high consumption households. And those include manufactured homes, mobile homes, and the like. The company also proposes certain other limited revisions to its tariff, including broadening compact fluorescent bulbs to the more general energy efficient lighting, which would include LEDs, and also adding other measures such as switch plate thermostats and refrigerator thermostats. DEC states the proposed tariff changes should improve the performance of the program and that the high consumption household measures could save the customers up to 2,200 kilowatt hours a year. The Office of Regulatory Staff have reviewed the proposal and do not oppose granting this request. Therefore, I move that we approve the request. So moved.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments?
I think, just to be clear, I was talking about switch plates, thermometers, and refrigerant thermometers. So,
thank you.
Thank you.
Thank you for that clarification. Okay, any other questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Item number 17, docket number 2015-163E. Duke Energy Progress requests approval for modifications to the Demand Response Automation Rider and Neighborhood Energy Saver tariff.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, Duke Energy Progress seeks to modify its Demand Response Automation Rider and Neighborhood Energy Saver tariff. The Demand Response Automation Rider currently provides a credit to customers who agree to curtail a minimum of 75 kilowatts of demand during peak summer and winter months. Participating customers receive 1, a control switch at no charge, 2, an availability credit each month at a rate of $3.25 per curtailable KW, and 3, an event performance credit for each curtailment event at a rate of $6 per KW reduced. After the second event, customers receive a $50 per KW credit to support the investments necessary to purchase and install equipment or institute process changes. Customers agree to participate in at least 3 events each summer, but no more than 10 annually. The tariff also includes a section describing opt-out eligibility. In this request, the company seeks approval to lower the required number of events from 3 events per summer to 1 event per summer and to reduce the minimum curtailable demand from 75 kW to 50 kW. Additionally, the company requests permission to raise the monthly credit from $3.25 per kW to $4.25 per kW and to update the section describing opt-out eligibility by eliminating references to deadlines that have expired. Duke states that all other credits and guidelines, such as the assurance that customers will not be expected to participate in more than 10 events per summer, will remain the same. The company maintains that these proposed changes should broaden the market set of medium and large industrial customers interested in participating in the rider, thereby encouraging greater participation in the program and improving its performance. The Neighborhood Energy Saver program uses third-party and census data to identify neighborhoods in which 50% or more of the households are equal to or below 200% of the federal poverty levels, and all households within an identified neighborhood are eligible to participate. Duke Energy Progress sends a team into those neighborhoods with a package of energy conservation measures to perform energy audits in the home to directly install the measures while on site. The company seeks approval to provide additional NES measures such as insulation, duct sealing, air sealing, and a smart thermostat to households within eligible neighborhoods that consume more energy per square foot than homes of similar size and construction, i.e. high consumption households, including manufactured and mobile homes. The company also proposes certain other limited revisions to the tariff, including low-flow faucet aerators to water-saving faucet aerators, and low-flow shower heads to water-saving shower heads, and HVAC winterization kits to window AC winterization kits. DEP states the proposed tariff changes should improve the performance of the NES program and that the high consumption household measures could save customers up to 2,200 kilowatt hours per year. The Office of Regulatory Staff has reviewed this matter and does not oppose granting the request. Therefore, Mr. Chairman, I move that we approve the requested changes to the demand response automation rider and the neighborhood energy saver tariff. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Mr. Chairman, moving to our transportation agenda, items number 1 through 3 are new applications that can be taken together. Item number 1, docket number 2020-27T, Delivery Solutions Transport LLC. Item number 2, docket 2020-30T, DAO Travels LLC, DBA Charleston Black Cab Company. And item number 3, docket number 2020-29T, Priority 1 Delivery and Transportation LLC.
Mr. Chairman.
Commissioner Hamilton.
Chairman, I'd move we grant the new applications and items 1 through 3 as identified.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Mr. Chairman, item number 4, docket number 2017-114T, we have a request for a name change.
Mr. Chairman,
Commissioner Belzer.
I move that we approve the request of Lou Ellen Warren doing business as Luxury Limousine Transportation to amend Class C Charter Certificate Number 9255 to read Luxury Limousine Transportation, LLC. So move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? If not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Item number 5, docket number 2019-147T, Miracle Movers Incorporated is seeking to amend its current tariff and scope of authority.
Mr. Chairman, before you take a motion on this matter, I would like to list that I'm not voting. It's well documented where I was and that I was on leave that day. Thank you.
Thank you. Commissioner Hamilton. Let's get your microphone on, Commissioner. Yeah.
Got it now. Okay, Mr. Chairman, I move we approve Miracle Movers Incorporated's application to amend its current tariff along with the request to amend Class C household goods certificate number 9835 to read statewide. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not all in favor, please say aye. All opposed, no. And the motion carries. Thank you.
Item number 6, docket number 2019-380T, we have a request for a tariff amendment.
Chairman.
Commissioner Howard.
Chairman, I move we grant the request of Upward Endeavors, LLC, DBA Two Men and a Truck of Greenville to amend the tariff. The Office of the Regulatory Staff has reviewed the application and has no objection to Upward Endeavors' request. According to ORS, it finds that the company is in compliance with Commissioner rules and regulations, including annual reports, gross receipts filing requirements, and has not received any customer complaints related to Upward Endeavors, LLC in the past 12 months. So move, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? If not all in favor, please say aye. All opposed, no. And the motion carries. Thank you.
Chairman, item number 7, docket number 2020-28A, the Office of Regulatory Staff seeks to change the format of certain reporting filings.
Mr. Chairman,
Commissioner Urban.
I move that we approve the Office of Regulatory Staff's request to revise the format for the bi-monthly reporting regarding automatically rescinded transportation orders. So moved.
Thank you. You've heard Commissioner Urban's motion. Are there questions or comments? Not all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you.
Item number 8, docket number 2018-172T, we have a request to cancel.
Mr. Chairman,
Commissioner Belzer.
I move we approve the request of Willie Lloyd doing business as Lloyd's Transport Services to cancel Class C non-emergency certificate number 9378. So move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries.
Item number 9, docket number 2019-270T, request of the Office of Regulatory Staff to revoke the certificates of certain motor carriers for non-payment of decal fees.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we grant the Office of Regulatory Staff's petition to revoke certificates of public convenience and necessity of certain motor carriers for non-payment of decal fees. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries.
Item number 10, docket number 2019-271T, we request of the Office of Regulatory Staff to revoke certificates of certain motor carriers for failure to maintain and file evidence of insurance.
Mr. Chairman,
Commissioner Urban.
I move that we grant the Office of Regulatory Staff's amended petition to revoke certificates of public convenience and necessity of certain motor carriers for failure to maintain and file evidence of insurance. So moved.
Thank you. You've heard Commissioner Urban's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Mr. Chairman, we have an administrative agenda item today. It's non-docketed item 2020-3A, and this matter involves a further presentation regarding our ex parte policy.
Thank you. And we'll welcome Ms. Boyd to the microphone.
Well, thank you, Mr. Chairman. Good afternoon. And I, in addition to, along with Attorney Joanne Westinger Hill, will be making a presentation regarding a draft ex parte communications policy.
Great. We also welcome Ms. Hill to the microphone as well.
Mr. Chairman, has everyone located your copies? If you on the bench, you should have a copy of the draft policy in front of you. So, Mr. Chairman, there are a couple of questions that we wanted to answer first regarding the draft. Of course, everyone knows and is aware that our ex parte communication statute is covered under South Carolina Code, annotated section 58-3-260. So, one of the questions that we wanted to enlighten everyone with, an answer to this question was, well, why do we need the policy? What's the purpose of the policy when we already have a statute in place? Our policy seeks to establish documented procedures or guidelines for all Commission employees to observe and follow so that Commission employees can comply with Section 58-3-260. The guidelines, including the creation of the ex parte communications policy team, which I talked a little bit about that last week, are meant to assist in the prevention of any improper ex parte communication, whether directly or indirectly, and to foster transparency and notice. Also wanted to point out, when we mention Commission employee as it relates to this policy, you should be able to find that phrase on page 2 under definitions of the draft. And the definition reads, Commission employees shall mean and refer to any person employed by the Commission, including but not limited to a commissioner, Commission hearing officer, Commission employee, or any Commission representative, agent, or consultant. Ms. Hill is going to answer the next 2 questions.
What must be reported? Well, we have proposed a definition of ex parte and ex parte communication. Ex parte is intended to mean whenever one party or less than all the parties are appearing or transmitting or delivering or communicating in some way, whether it is oral or written, with a commissioner, commission employee, which would include anybody that is representing the commission. So if you've hired someone or engaged someone, that would also include them as well. It ties back into the definition of commission employee. The ex parte communication is actually the information, whether it is in document form, oral form, written, or electronic, of what is being transmitted to the commission as it relates to a matter pending or potentially, and this is where we get into the definition of what is a proceeding, because that's really important. The code itself in section 58-3-260 did define what a proceeding would be, and proceeding can mean a contested case, a generic proceeding, or any matter to be adjudicated, decided, or arbitrated by the commission. So it is a rather broad definition that'll be encompassed by this.
Okay, so next, Mr. Chairman, I have really the same topics that I had included in the slide deck last week. Just added some subtopics under each. But I think this is the slide that you're viewing right now. Looks a lot like the one last week. The tools for communicating, you might recall last week that I mentioned that in cases, sometimes not all parties have or utilize an email address. So we needed to make provision for those instances when all the representatives, whether they're lawyers or non-lawyers who are representing themselves, that the communication is received the same way by everyone. And if everyone does not utilize email, that we needed, as the agency, we needed to come up with some other ways for the ex parte communication to be, or the communication rather, to be transmitted. So beginning on page 4, you'll see where we've organized certain issues under section 2. For example, section 2A on page 4 covers matters that are currently filed or pending before the commission. Page 6 covers, section B, covers matters not currently pending before the commission, or perhaps they're impending. And what the policy basically does, it comes up with one way of transmitting the communication, meaning that if there is a pending docket or pending case, if the trial here, so to say, has not started, the case has not started in this hearing room before you, then that information at a minimum needs to be transmitted to the parties in the case, whether that's by email, video recording, or audio recording. And if the case is currently in process here, Ms. Wheat's present and she's recording it, then it also needs to be made a part of the record in the case, part of the transcript. Okay, so that procedure would apply, the same procedure. How parties are notified. First of all, if whether it's pending or not pending, the staff or the commission employee who's in receipt of that information will need to prepare a memo. That memo could be in the form of typing it as an email, typing a letter, typing a memorandum. So that's kind of, in my mind, that's the first step. Then the next step would be, of course, notifying the parties, serving the parties in the case. Now, the memo, email, letter will take place, of course, if all the representatives in that case have an email. If they don't have an email address, then another tool would need to be used. For example, we talked last week about using our TriCaster in the back there, where we currently use it to live stream. Ms. Purvis has agreed to record the commission employee, and we can transmit the information that way. So first of all, we're either going to prepare a memo. I'm combining actually a couple of things here. I'm combining whether or not the matter is pending, whether or not the matter is not pending, and I'm also combining whether or not everybody has an email address when I'm talking. Because we didn't want to have different rules. We wanted to have the same set of rules, the same procedures, so we don't have to think, okay, what do I need to do? You should be able to follow the same process, no matter what the issue is, no matter where the case is pending before the commission. All right, so you're going to prepare your memo, whether it's an email, letter, memorandum. If everyone has an email, if everyone does not have an email, we got to use the video recording or the audio recording. So you're going to use one of those 3 tools, 4, what I have 5 up there, tools, depending on the situation. We got to make sure everybody in the docket is notified. And then we also have to worry about service. Now, as you're aware, we currently utilize General Assembly approved our regulation where we can serve notices and pre-file testimony letters and transmittal letters. So we can utilize DMS if it's during working hours and the employees are here to place either the email, the letter, or the memo in the docket and then electronically serve everyone. If we don't have, for example, an email address for everyone, we still would place that matter as a matter in DMS and a link to where they can find the video on our website. So basically, I don't want to make this sound complicated. The basic steps are come across a communication that needs to be reported, take the steps to either write a memo, write an email, write a letter. Everyone has an email address. If they don't, you're going to have a video recording or an audio recording. Step 2, notification. And step 2, notification and service, notifying the parties and service should probably, I would think, need to be simultaneous. Okay. All right, so documentation for parties without electronic service, that's covered on page 8. And I just covered service. I let you know that our DMS has the capability to do that.
The next question, of course, is when do you do this? The statute itself in 58-3-260 does reference 2 terms, promptly and also a term or a phrase, as soon as it is known to relate to a filing. Promptly is probably one of the easier ones to define, because once you know when you got a pending case or a matter that's already pending or filed or to be pending or in it currently proceeding, that's easy to do. But how you define promptly is that it shall mean the same business day in which such ex parte communication is discovered or known, or if discovered or known after the close of the normal business hours during a holiday or a weekend when we may be off, then promptly shall mean the next normal or regular business day of the commission. So basically, you're supposed to do it once you know about it, as soon as you discover it or know it. Promptly means do it then. If not, if it's after hours, can't do it, need to wait, or a holiday or weekend, you wait till the next normal business day arrives in order to do so, to promptly report it by following those procedures of putting everything in writing, or, as Ms. Boyd mentioned, the video recording, the audio recording. The other phrase, which is also used in the statute, is as soon as it's known or relate to a filing. We're going to keep it simple with regard to it. It's going to mean the same business day in which the commission employee, which means a commissioner, hearing officer, or anyone representing the commission that is hired by the commission, discovers or knows that such ex parte communication relates to a new matter or filing with the commission. That would also include if it's discovered or known after the close. If it's discovered or known after the close of business hours, same thing applies, or after during a holiday or weekend. You must do so within the same business day or the next regular business day, should it be after hours, holiday, or weekend.
Okay, Mr. Chairman, so the last bullet point covers our ex parte communications policy team, and that appears on page 13. Basically, the team shall be comprised of 1 commissioner, chief clerk, chief legal counsel, staff attorney, and a non-lawyer. And the chairman of the commission shall administratively appoint the persons who shall serve on the team. And as you can see at the top of page 13, some examples of what the ex parte communication, the duties of the ex parte communications team include: meeting at least annually, reviewing the ex parte policy, making recommendations concerning the ex parte policy. So all of that is listed there on pages 13 and 14. Okay. So today is the 29th. This slide up here was in the deck last week too. Today's the 29th. We've completed our presentation of the draft. And so I think we're available for questions or whatever other action the commission wants to take, Mr. Chairman.
Thank you. Commissioners, questions? Commissioner Belser.
Thank you, Mr. Chairman. Ms. Boyd, thank you, Ms. Hill, for working on this policy. Last week I asked, this is an internal policy, is it not?
That's correct. Yes, sir.
And I think that I see that written public comments filing deadline with the commission. If this is an internal policy for all employees of the commission, commissioners, staff members, consultants, whoever, why are we putting this out for public comment? It's not a regulation.
Well, it's your decision as commissioners as to what. I have my thoughts about why I propose things, but.
Well, I understand that you're promoting transparency, and I appreciate transparency as well. And I think that having discussions here in the commission meeting lend to that. But I also think that it is incumbent upon this commission body to implement the policies which we will follow and which apply to staff. And I understand that this is to provide some guidance and clarification to all of us on how to conduct ourselves and to avoid prohibited ex parte communications, and how to respond should we initiate or receive a prohibited ex parte communication. And as such, I mean, I think we've got the rules, the statutes that govern us, and I think that this is incumbent upon us to develop the policy. I have no problem with it being made public once it is fully developed and vetted from internally. I just don't know why we are seeking comment from outside the commission on how to.
Are you rejecting my proposal?
Yes.
That's
I
fine,
would move that we not issue it for public
Okay,
comment,
that's
that we review it internally and make whatever edits and bring it back to the commission to finalize it. And then at that point, I have no problem with it, that, you know, we share it with other parties should they request it or want it. But I just don't know why we would send it out for public comment when it's a totally internal policy here. It's not a regulation. I mean, I know it's helpful to all of us, and that I look forward to perusing it and reading through it further. I've already made some notes, but I do want to study it a little more.
Sometimes, I mean, this does impact, as I said, it was just a suggestion. You all have the final say. But sometimes, since this does, although the communication is received by commission employees, others will be impacted because they will be the recipients of this information. So, as I said, you know me, I'm just thinking broader than most as to who might have something to say, even though they are not the recipients, are not initiating the communication, they are still a part of this process. But I don't have a problem with that, of course, at all, Commissioner. You all have the final say. I like telling you what I think, and then you all take the vote. You're the governing body, not Jocelyn.
I'm one commissioner. Others may feel differently, but yeah. I would move that we not issue it publicly, that we continue to review it internally, and provide any edits, suggestions to Ms. Boyd and Ms. Hill by February 12th. To stay on schedule, but that's just one person, one commissioner.
Okay, so we have a motion on the floor from Commissioner Belzer. We'll take additional comments and questions. Commissioner Whitfield.
Mr. Chairman, I want to address Commissioner Belzer's motion. Commissioner Belzer, I certainly respect you and have the greatest faith in your legal mind and all those sort of things, but I do want to say that if you notice on the 19th, February 19th, the commission will have final say, as Ms. Boyd has said, and this is, as you stated, an internal policy by this body, by this commission. However, there's so many areas of our law, Act 175, the Judicial Code, other ethics laws that govern this subject matter, and certainly the public has a right, when those laws are being crafted, to contact their senator or House member in that regard. And at first I thought you might be going to just limit it to the parties or who come before us, or intervenors, attorneys, and maybe even public members that come before us. And I was wondering where you were going with this, but I think I'm respectfully going to have to vote against your motion. I think the public, it is our final say. As Ms. Boyd said, we will have the final say, but I do think on something this important, even though it's our internal policy, that we give the public or parties who come before us the opportunity to be heard in this final rulemaking. That's just my opinion, and that's all I have, Mr. Chairman.
Thank you. Other comments, questions? Okay, if not, we'll take it to a vote. And please vote where we can hear you. All in favor, please say aye.
Aye.
All opposed, no.
No.
Okay, I believe the motion carries. Okay.
So, Mr. Chairman, if you don't have a problem with it, we will place this item back on the agenda on February 19th.
Yes, ma'am.
Okay,
That would be good.
all right. And so I think that completes the agenda. We have a rulemaking after this, Mr. Chairman. It's notice for 2:30 today.
Yes, ma'am. Okay, so nothing else to come before us in this meeting. So we will, Mr. Minges.
Well, just to say, Mr. Chairman, yes, sir, that completes today's agenda.
Okay, thank you. Okay, we're gonna, when we adjourn this meeting, we're gonna take a short break to let the court reporter and the live stream get recalibrated, and then we will start as soon as possible. So we are adjourned. Thank you.